Employment Roundtable podcast is produced by the GableGotwals law firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel. Welcome to the Employment Roundtable, where we provide you with the perspectives and information you need to make wise employment decisions for your employees and your organizations. I'm your host, Talitha Ebrite, and today we're talking with Holly Cole, Director of the EEOC in Oklahoma, and my GableGotwals partners, Paula Williams and Ellen Adams, about the increasing prevalence of artificial intelligence and what the EEOC recommends to safeguard employees from potential AI pitfalls in the employment context. So, Holly, let's start by asking you, we know it sometimes takes a bit of time for the impact of new technology to start to show up in legislation and regulation and court decisions. But to what extent has the EEOC begun to feel the impact of the use of artificial intelligence in the employment context?
Yeah, thanks, Talitha. And actually, in 2021, Chair Charlotte Burrows of the EEOC launched the Artificial Intelligence and Algorithmic Fairness Initiative to do
That's
exactly
what mouthful.
Yeah, it is a mouthful, and it'll probably have an acronym at some point that would be AIAFI. So, in any event, that initiative was designed to look into the use of artificial intelligence and, how prevalent is it? How is it being used in the employment context? And so when we're talking about artificial intelligence, we're thinking about algorithms and all kinds of data and all kinds of automated systems that employers could use, say, to advertise and hire employees. So you can go online, right, and you fill out your job application. Well, chances are there's a lot of AI involved in that. There's a computer who's evaluating your application and the answers that you put on that. As a matter of fact, some of the estimates are that 99% of Fortune 500 companies are using AI in their hiring practices. So it's very common. We are still at the beginning stages of looking into it and seeing, what kind of impact it is. But it is one thing that's clear is that although these systems can be very helpful, if they're not designed properly and used properly, they can have built-in automated discrimination decisions being made that maybe kick a particular applicant out of the process just because they took too long with their keystrokes or something like that. So this is one of those areas of law that's kind of, George Jetson is fascinating and involves a lot of technology that, quite honestly, I don't understand. But like anything else, it just has to be a tool that doesn't permit discrimination. It can't be used for an impermissible purpose.
Great. Thank you so much. Now, Ellen, kind of building off of that, it seems like this is a potential minefield for employers who both want to take advantage of time-saving technologies and efficiencies that are inherent in AI. So where do you recommend that employers start so that they're doing their best to mitigate their legal risks relating to the use of AI?
Yeah, great question. And you're right. I think minefield is how, as an employer defense lawyer, I see this whole area of the law for employers. The EEOC, the laws that the EEOC enforces are all specific that the employer is the one with the obligation. So just because you're utilizing a tool or technology or a vendor who's supplying the technology does not create a layer of liability in and of itself that the EEOC is investigating employers. The statutes and regulations that they're enforcing target employers. So the employers are the ones that have to ensure compliance. And when you're negotiating over this type of technology, an employer is doing this probably for all the right reasons. One, efficiency. I can get through a whole volume of applications a lot faster. The other side of that is I can eliminate humans who potentially have bias that either they're unaware of or they are aware of. And so I can use this tool and technology to go through all of these and take that out of the equation, which avoids discrimination, right? But problematically, if you don't understand the technology that you're utilizing, you're potentially having results that have a discriminatory impact. And it's important for the employer to understand the technology and ask questions about how the algorithm is going to work, who's going to get weeded out at various stages of the application process and on what basis, so that they understand what they're buying. And then, of course, anytime you're negotiating a contract with a vendor, there's language that you can ensure are in those contracts to protect you from liability, or at least it won't protect you from liability from a claim, but it could help you offset whatever you're required to pay in damages by virtue of the vendor taking on some of the responsibility for legal compliance. And this is tricky, because if you really want the service, you don't have as much negotiating room. But I would really push employers to negotiate on that point and say, this is new technology. I don't understand how it works. You're telling me how it works, but I want you to take on the responsibility of legal compliance. And if you're sure that it's not going to get me in trouble, then you indemnify me, so that if I am in trouble, you're on the hook too.
Well, and also maybe clarify that, we something that avoids discrimination is one of our goals with this, right? So if you're clarifying that in your agreement, that's probably really helpful too.
Absolutely. Yeah, including that language that, legal compliance is the responsibility of the vendor, and the goal of the employer is to, ensure compliance with Title VII and the ADA and on, and all the different laws and regulations that employers are obligated to.
Right. Great. Good stuff. So now, Paula, we talked a little bit about that the EEOC has issued a fair amount of guidance on AI. And in the wake of that guidance, what claims do you anticipate seeing in this space?
Well, Ellen mentioned disparate impact. So on this podcast, traditionally, we've talked mostly about intentional discrimination, intentional acts of limiting someone's advancement or termination in the workplace. But the use of AI could increase disparate impact claims. And with a disparate impact claim, we're looking at the rate of selection. So what effect did a policy have on the opportunities that someone in a protected class had to be chosen for that job? It could be facially neutral, which means we look at the policy and facially it looks like it's fine. So I'm going to give you a classic example, and then one that I came up with last night, so buckle in, about AI. So a very classic example is employer wants to recruit for an accounting position in the back office, someone who's going to do accounts payable or receivable, but they slap a 50-pound lifting requirement on the essential job function. Well, that is more likely to weed out women than men. And so it's facially neutral. Everybody has to meet the same lifting requirement, but the law is going to say, well, hey, is that actually required for the job? Because if it's not, is it having the intentional or unintentional impact of preventing women from applying to that role? Now, given the day, I can lift 50 pounds. I know that Talitha can too, but not everybody is a Paula or a Talitha. I couldn't do the accounting though. So that's one example, facially neutral policy. So as I was thinking about AI, well, let's say we tell the AI program, we want to weed out resumes that have a 2-year gap in the last 10 years or in the last 3 years. And the employer says, you know what, I get all these applications and people who did this job 7 to 10 years ago, but I don't want to retrain them. This industry's changed a lot. So computer, let's weed out any resumes where there's a 2 or more year gap anywhere between 2015 and 2023. Well, it's facially neutral. It would be more likely to disadvantage women who may have stepped out of the workforce during a period of caregiving. And additionally, it may actually have no semblance of whether the person is still qualified and understands how to do the job, or whether they did outside training to stay current with how the job changed. So those are just two examples of how disparate impact works. And I think that's what we would see arise in this new age of artificial intelligence.
Okay, thank you. That's really helpful. So now that we know kind of what some of the anticipated risks that we see are, what are some best practices that employers can implement to avoid, this type of liability or these type of claims?
All right. Well, Talitha, to answer this, we have to do math. And so are we ready to do math today?
Yeah, let's do it.
Okay. So the EEOC guidance, which is very helpful because, as we've said today, this is a new area, and I'm sure there will be more guidance in the future. But the EEOC says that employers should regularly assess whether their selection protocol has this kind of adverse or disparate impact on a particularly protected group. Well, how do you regularly assess? How does one do that? Well, the EEOC gives guidance there too. And they say that employers can evaluate the selection rate for individuals in different groups. The selection rate means you're looking at whether a group is selected, and I'm quoting here, substantially less than individuals in another group. All right, well, if we're putting on our thinking caps, what does substantially less mean? In the law, if we're making sure we're compliant, what is substantially less? When the employer is looking for the proportion of times that someone from one group is selected as compared to the proportion of times someone in another group selected. So the EEOC provides an example to put into place the 4/5 rule. And the 4/5 rule is what requires math. And my husband is far better at math than I am. And I'm going to make sure he listens to this episode. So here's the example the EEOC provides. Let's say 80 white potential employees and 40 Black potential employees take a personality test that's scored using an algorithm, using AI, as part of their job application. Now, out of those 80 white applicants, 48 and 12 of the 40 Black applicants advanced to the next round. If you are listening, you may want to write those numbers down to do our math. I have it in front of me. So based on these results, you can trust my math here. The selection rate for the white applicants was 48 out of 80, which is 60%. And the selection rate for the Black applicants is 12 applicants out of 40. That's 30%. So we had 60% of the white applicants move on. Just 30% of the Black applicants move on. So is that substantially less? Well, under the 4/5 rule, the EEOC says this is a rule of thumb. So it doesn't always govern the day. It's just a rule of thumb for determining substantially less. And it says that one rate is substantially different than another if the ratio is less than 4/5 or 80%. So in the example I just discussed, that selection rate for Black applicants was 30%. And white applicants was 60% that moved on. The ratio of those two rates is 30 over 60, which is 50%. Because 50% is lower than the 4/5, the 80% that we need to be substantially less, the 4/5 rule would say that that selection rate for the Black applicants is substantially different, which could evidence discrimination. So this is hard in my view. And as Ellen was mentioning things to negotiate with your vendor, think about how the vendor is going to test this. Are they prepared to help you determine the selection rate and apply the 4/5 rule to the algorithms that they put into place? That way, you have touch points with your vendor where you can test the algorithm and make sure that you're compliant.
Mm-hmm. And Paula, you raise an interesting point when you're talking about personality tests. I think that is such a slippery slope anyway, even if you're not talking about AI, because how often does someone's personality, does that matter? Is that an essential function? It seems to be so subjective. So I mean, I can see how it would be relevant in some instances, and it's certainly interesting information to know. But not sure that if you want to say this is an essential function, if you have this personality type, we want you on our team. I think that's a little bit suspect.
Right. It kind of gets into that sort of, nebulous concept of fit and,
subjectivity,
which
culture.
right, which often means how like us are you, right? So,
yes.
Yeah. Well, good stuff. Thank you so much. I especially enjoyed Paula's beautiful mathematical proof. It was just really well done and very clear. Thank you so much. So thanks to all of you, Holly and Paula and Ellen. It was great talking to you today. And thanks so much to all of you for listening. We'll look forward to seeing you next time. The Employment Roundtable podcast is produced by the GableGotwals Law Firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel.